to empower families across New York State. Our goal is to assist you to establish a family council within every facility. Before we get started on today's presentation regarding HIPAA and what it means for families, which will be presented by Deborah Terhowski, we need to just share the disclaimer. This information being discussed today applies to New York State only. Please don't share personal information about your loved one during today's meeting. This program is being recorded and live streamed on Facebook simultaneously. Please mute yourself so everyone can hear clearly. We will be taking questions, so please raise your hand. If we don't get to your question, please write it in the chat along with your email address so that we can answer you. Have you ever been asked to leave your loved one's room because staff needs to provide care or to change them? Have you ever thought about placing a video device in your room where your loved one lives, but the nursing home told you they don't allow it? Today's discussion will provide some clarity and insight for you going forward. Deborah Terhowski is a prominent New York nursing home abuse attorney. We're thrilled that she's here today to discuss with you everything you need to know about nursing home privacy in New York State. Thank you to LTCCC for hosting this half hour. The LTCCC, the Long-Term Care Community Coalition, is a nonprofit organization dedicated to improving quality of care, quality of life, and dignity for elderly and disabled people in nursing homes, assisted living, and other residential settings. They are also home to 2 ombudsman programs within New York State.
Janine, would you like me to begin? Or?
Yes, thank you so much.
Okay, you're welcome. Janine, thank you. And it's wonderful to be here with everyone today. I will absolutely cover the important topics that Janine mentioned, and I thought it might be helpful to address these important topics in the context of potential ways to identify abuse or neglect. And when I think about ways to identify abuse and neglect, I feel it's helpful to break them down into 3 categories of look, listen, and smell. In terms of look, what I mean by that is to really look at the resident. Are they being well cared for? Has the resident lost weight? Does the resident have bruises that are unexplained or bed sores? And in terms of being well cared for, what I meant was referring to is the person bathed, are their nails trimmed, are they getting their hair washed and cut? And in terms of listen, what I'm referring to is, what is the resident saying? Do they have certain complaints? And even if someone has dementia or Alzheimer's disease, it's still important to listen to those complaints. Also, do you ever hear the staff engaging in any type of verbal abuse? And lastly, under listen, is the resident no longer interested in, if someone can mute, I'm hearing just some background speaking. Okay, thanks so much. So in terms of that last component of listen, is the resident no longer interested in pursuing activities that he or she used to like to do? Do they no longer want to go to the lunchroom, or do they no longer want to go to an art class that they used to go to? And lastly, under the category of smell, is there a strong odor of urine in the resident's room? Or are there foul smells in the resident's room? Foul smells could be indicative of someone having an infected bed sore, for example. So in order to properly be able to look, one of the things that's important to do is to be able to stay in the room. And I know that I've often heard from family members that they're told that there's a rule that you have to leave the room when a resident is being changed. And I want to share with you that there's no rule that says you have to leave the room. There is a rule that can relate to HIPAA, and I want to talk about HIPAA, but that's it. There's no rule that says when a resident is being changed, you have to leave the room. So in terms of HIPAA, probably most of us have heard of HIPAA. It even comes into play when we're going to doctor's appointments ourselves. And HIPAA stands for the Health Insurance Portability and Accountability Act. And this is a federal law that was designed to provide privacy standards to protect patients' medical records and other health information that's provided to health plans, doctors, hospitals, and other healthcare providers. And these standards are important, and they provide all of us with access to our medical records and more control over how our personal health information is used and disclosed. So again, it is important that we have these privacy rights. However, what I have seen in some instances is that HIPAA can be used as a shield, and it should be used as a shield if someone is asking for information who's not entitled to it. However, it should not be used as a shield when someone is entitled to information. So you may be asking, well, who is entitled to this information? Well, first is the healthcare agent. If a person has signed a healthcare proxy and they're no longer competent to make their healthcare decisions, then the healthcare proxy would kick in and the healthcare agent would be allowed to make healthcare related decisions that the person would have made for themselves. The second is someone who is called a surrogate decision maker. And I'll explain a little bit more about what that means in a few minutes. And then lastly, guardian of the person. And that's a guardian that's been appointed by the court in order to handle anything related to the individual, such as healthcare decisions, where the individual would reside and things like that. Now, in terms of staying in the room, what do I recommend? So if a facility says to you, you need to leave the room, then have a conversation with them and explain what basis you have to stay in that room, such as you're the healthcare agent, or as I'll explain in a moment, you might be the surrogate decision maker, or again, the guardian of the person, or most importantly, the resident can give you permission. The resident can say, yes, I want my son or daughter to be able to stay in the room when I'm being changed. And I recommend that just when you stay in the room, just to say to the facility, to the staff member that's coming in to do what they need to do, I'll just stay over here and let you do what you need to do, but I do want to stay in the room. And I think most of the time, the request to leave the room comes from the fact that they're busy, they want to get in and get out, and they feel like if someone's in the room, it may delay that. So if you put it in this type of context, I think it's hopefully more palatable and you'll get less resistance. But I do want you to know, if you do get resistance and you fall within one of the categories that I've discussed, that you have a right to stay in the room. And if they continue to give you opposition, then I would speak to people at the facility. And if that doesn't help, then I would suggest contacting the ombudsman for assistance with that. And I wanted to share with you an experience we had with a family we represented quite a few years back that really embodies and accentuates the reason to be observant in terms of the criteria I was listing about look, listen, and smell. And in that particular family situation, a granddaughter was the healthcare agent for her grandmother. And her grandmother had dementia, but she didn't have end-stage dementia. And when the granddaughter visited, she noticed that there were unexplained bruises on her grandmother's hand. So that would fall under the look column. And she spoke to the facility. They really couldn't explain what it was from. And so she then spoke to her grandmother and said, what happened to you? And her grandmother made this hitting motion on her own hand. And the granddaughter thought that was strange because she had never done anything like that before. And also, while she was visiting, she would hear a staff member being very loud and abusive with other residents, so much so that she went to the hallway to figure out who was this person talking to in such an abusive way. And the granddaughter was concerned. She wasn't getting answers from the facility. And so she decided to put a hidden camera in her grandmother's room. And this hidden camera, unfortunately, confirmed her suspicions that her grandmother was being abused. And with that video, we brought that to the Attorney General's office, to the Medicaid Fraud Control Unit, and they did use that video as a basis, after, of course, conducting a thorough investigation, to charge that aide. And thankfully, because this granddaughter was observant, she trusted her gut instincts, this aide now is no longer able to abuse any other residents in the future. So I want to explain what I mentioned before about the healthcare, about the surrogate decision maker. I'm very happy to tell you that in New York, we have the New York State Family Healthcare Decisions Act. And this is a really important act because what it does is it establishes the authority of a patient's family members or close friends to make healthcare decisions for the patient in cases where the patient no longer has decision-making capacity and did not appoint a healthcare agent. So this act comes into play when someone does not have a healthcare proxy and again is no longer able to make healthcare decisions. And it's good to know that this surrogate decision maker would also be empowered to direct the withdrawal or withholding of life-sustaining treatment when standards that are set forth in this statute are actually met and satisfied. And we've actually had this Family Healthcare Decisions Act since June of 2010, and it's been updated, but it is very important. And I want you to know that even if there is no healthcare proxy, that under this act, that there are specific individuals that do have the ability to act on behalf of a resident and their loved one or friend even. Also, getting back to the idea with respect to videotaping and several important things that I want to go over with respect to that, because I know that was one of the other important topics that we wanted to cover today. So as I mentioned, this granddaughter, she went and she got this hidden camera and put it in her grandmother's room and found this abuse. And I often get questions about, well, is it permissible? Can I put a video camera in my loved one's room? And so basically, with certain parameters being met in New York State, this can be done. So for example, first, the person doing it has to have the authority to do it. And that's similar to the HIPAA authority. First, is the person the healthcare agent? Is the person the surrogate decision maker? Is the individual the guardian of the person, or has the resident consented to it being done? That's very important because this camera is going to be capturing the person getting care, treatment, and so someone needs to have that capacity to do it. Second, it needs to be video only. And the reason is that in New York State, we have a wiretapping law. And in this wiretapping law, it basically says that we are a one-party consent state. And what that means is that one party to the conversation has to consent. So if you were to place the camera and then leave and have it recording while you're not there, it would violate the New York wiretapping law. So that's important that it's just video. And lastly, what's important is that only the resident is depicted in the camera line or angle. If someone has a roommate, you want to make sure it does not include the roommate because the roommate has not given his or her authorization to be included in the video. So those are three important things to keep in mind in New York State if you're considering using a video camera. And I want to see if, I know we wanted to potentially see if there was some time for questions. I can also, so maybe I'll just cover one more topic before I let us go to questions. Whenever I speak, I always like sharing with everyone that not only is it morally and ethically appropriate to treat residents properly, but that we have very powerful and inclusive laws, both at the state level and the federal level, to protect nursing home residents. And we have federal laws. There's the 1987 Nursing Home Reform Act, which mandates, and it was the basic purpose of this statute was to ensure that nursing home residents receive quality care and that they receive care that will achieve and maintain someone's highest practicable physical, mental, and psychosocial well-being. This act established a survey and certification process. And once this act was passed, regulations were then put forth to really give teeth to this act. So we have federal regulations that set specific standards and care. And we also have New York statutes. There's a wonderful statute, the New York State Public Health Law, Section 2801D. This act was passed to actually give residents the ability to bring a private right of action or a lawsuit against a facility if a person's rights are violated. And New York State has regulations that actually address specific nursing home care, adult home care, assisted living residence care, and also home health care. And so there is a lot that supports providing residents with appropriate care. And my last point I want to make is the thoughts that I shared with you regarding look, listen, and smell, they apply not only to nursing homes, but really in any care environment, which would be hospitals, assisted living, or in home care settings. It's good to follow that type of observation in any context where someone is receiving care. Thank you, and I'll open up to see if there are questions at this point.
Thank you, Deborah.
You're welcome.
Amy Garrick poses a really good question. How do you get around the facility that has a policy for no cameras in their admission packet?
I would question that. I would ask them what is the basis for that. And because what I've always found really compelling in terms of establishing why someone can do this is someone's home. The nursing home room is someone's home. And in someone's home, they would be allowed to do this and question the basis for this facility saying that it cannot be done.
Okay, so Amy writes, they say it's for privacy of the staff.
The staff does not have a right to privacy. They're at work, they're performing a job, and there's no right to privacy on behalf of the staff. I don't believe that that's correct.
Okay, thank you for that. And
you're welcome.
Francis Duffy asks, can a state ombudsman access a resident's medical records without the resident's permission?
Well, I would defer that to the ombudsman program. I believe that they can, but if someone from the ombudsman program or on behalf would comment, I would feel that would give a more accurate answer than myself, if you're comfortable with that.
Gloria, what say you?
Gloria, you're muted.
Yes, thanks. So I do see that there are other ombudsmen from New York State on. I am not actively working as an ombudsman in this family council, but am familiar with the regulations for the ombudsman. And if any of the other ombudsmen that are on the line want to hop in with me, please unmute yourself. But the state ombudsman is the final person in an investigation who can grant, who can give permission to the ombudsman regional director to investigate if there is no one on behalf of the resident and the resident cannot communicate if there is suspicion of abuse, neglect, or anything like that. So there is a process for it. It's not like she can just say, yes, go ahead and look at medical records. There is a process of investigation that has to happen prior to that as well. And again, I welcome any of the other ombudsmen to hop on that discussion.
Sure. This is Judy, Region 4 of the Ombudsman Program. If the resident consents to the investigation, then as part of the investigation, the ombudsman can look at the medical records if we have the resident's consent. If there is a problem, especially of abuse or anything of that nature, the resident doesn't consent, then as Gloria said, we would consult with the state ombudsman.
Thank you, Judy. You are a godsend, as I've been telling you for the last 2 years. Thank you.
Oh, you're welcome.
Any other questions?
There is one, Janine, from Gloria Boyd that says, can
Oh,
the
yes. Husband stay in the room. Thank you, Gloria. And thank you, Gloria Boyd.
Again, with respect to the ombudsman's ability to stay in the room, I would feel more comfortable with someone that is affiliated with the program to answer that question. I was speaking from a standpoint, again, of who would have the authority based on a family member or friend being able to stay in, and therefore, again, the healthcare agent or surrogate decision maker, et cetera.
So I'll jump on here, and again, any of the other ombudsmen hop on with me, but I would be questioning why an ombudsman would want to stay in a room with the resident during their care or their changes. If they are doing an investigation, obviously we're not clinical, so we can't really judge anything from a clinical perspective because no ombudsman is on a clinical level when they're working an advocacy program. So it would depend, and I would say that I would put that question up to your regional directors or your state ombudsman.
And Janine, one point I wanted to make, which reminded me of something when Gloria was giving that response, is that one of the reasons from a family standpoint or friend standpoint to stay in the room and look is that bed sores or pressure ulcers are developing in areas where a person wouldn't typically see this. Bed sores develop on areas where there are pressure points, such as the low back, the buttocks area, elbows. And so by staying in the room, if someone is incontinent and they have an adult diaper and the adult diaper is being changed, that's often the only way, or not often a way that the family member could find out if there is any type of skin breakdown. Because in my practice, we're often contacted by families when a pressure ulcer is quite serious. And I interchange the words bed sore and pressure ulcer basically are synonymous terms for the same thing. And so if a family member stays in the room and when someone is being changed, they look at their backside and see it all nice with no red or breakdown, that's perfect. If they see red or open wounds, then that's something that would be important to speak to the staff about and ask, what is this and how is it being taken care of? And so that's one of the important reasons to stay in the room. So, thank you.
Thank you. Thank you, Deb. Michelle, you have a question? If you can please unmute.
Thank you. Yes, I do. Thanks, Janine and LTCCC for the invite to this nice half hour. And Deborah, I do have a question for you. Wait, I'd like to introduce myself actually first. So I am an advocate primarily for the veterans who live at the veterans homes in New York State. However, my dad passed during the COVID lockdown, and I just wanted to say that those of us, there's like this growing trend of people who have lost their loved ones who have remained to stay on through advocacy. And I really want to support and encourage this trend, because I know from my personal perspective that, there are benefits to this, because my priority is not on that person that I'm trying to protect and advocate for who lives in the nursing home, still have been there. So I want to I know there are several people on the call today who are in the same position. But Deborah, thank you. I want to ask a question I want to know how easy or difficult it is for a resident without family members to change their power of attorney or healthcare proxy. Are there resources out there available to them if they don't want to work through the social workers at their skilled nursing facility? Do you know?
Well, it's an excellent question. And I'm aware of groups like NILAG, the New York Legal Assistance Group, which I know is terrific. They can help, I believe, with some things like this. I also believe the New York City and maybe other people on the call, I'm just trying to remember the name of, I think one of the state agencies might be able to assist with that as well. So I would ask if anyone is aware of that to let me know. Otherwise, I can actually look into that further and get back to you with respect to that.
Thank you. I'll put my email address in the chat.
Okay.
Thank you.
Thank you,
so
Michelle.
much.
You're welcome.
Thank you, Michelle. Thank you, Deb. Faye, you have a question? Fidelia? Wait, sorry, Faye, you're muted.
Okay now. So one of the questions I had to do with the camera.
Mhm.
And of course, probably many of us think like, what really goes on when we're not here? If you put that camera in, do they need to know that you put that camera in? If you put obviously, probably not. But what if that camera is removed? Can they remove the camera if they take the camera out? Do you have any recourse?
I do not believe you have to tell them you're putting it in, because again, it's the resident's room and they have a right to do with what they want, as long as the person doing it has the capacity to do it. If they take the camera, I feel you would absolutely have recourse. That is your property on behalf of the residents. And I would absolutely demand that it be put back and given back.
Thank you.
You're welcome.
Thank you, Faye. Thank you, Deb. There are a few questions in the chat. Let's see. In the chat, we've got Kathy Armont. Oh, actually, forgive me, Kathy. Before that, Francis Duffy asked, my facility does not have a family council. Is this a mandated thing?
My
Why?
understanding,
Go ahead, I'm sorry.
is that they absolutely have to allow family members to create a family council, and they cannot prevent it. They can't do things to discourage it. They absolutely have to allow it, and I believe take steps to help families implement it, is my understanding. But I know LTCC probably can comment even more thoroughly with respect to that.
Thank you. Thank you for that. Okay. And
You're welcome.
then let's see. Amy Garrick had just mentioned that, yes, the OFA has an agreement for legal services. They have a rural law. Kathy Armont asks, would you first have to get guardianship in regards to Michelle's question?
Michelle's question was about changing the POA, or?
Yes.
Well, that's a great point. So if the resident no longer has capacity, then neither the healthcare proxy nor the power of attorney can be changed. The only context in which someone can change their health, can create a healthcare proxy or a power of attorney or change either of those documents, is if they have the legal capacity to do so. So if someone no longer has capacity, it cannot be changed. Now, yes, someone can have a guardian appointed, but in order to change the representative through a guardianship, it would need to be shown to the court that the person designated by the individual either can no longer act, let's say there was some illness or disability, or they died, or they're not fulfilling their fiduciary obligation properly. But the court will typically really hold that to a high standard because they want the person's wishes to be recognized. If someone says they want their daughter to be the healthcare agent and a son decides he wants to do it, well, that just can't happen unless the daughter is not properly fulfilling her responsibilities. So the court really needs to see that someone is not fulfilling their obligations to change something like that. But a court proceeding would be necessary to change it if the person no longer has capacity.
Great answer. Thank you. Thank you, Deb. Are
You're
there
welcome.
any more questions? No? I hope you've enjoyed our half hour here and you're able to glean some information from this. If you haven't signed up for the newsletters or the webinars for the LTCCC, please sign up. It is an informative, policy-driven organization, and we're always looking out for everyone's rights in every state in this country, and we aim to give residents that feeling that their facilities are resident-centered once more.